All right, I'm not going to give any introduction to... Siddharth is a high flyer. Oh, okay. All right, so nobody requires any introduction because I think they are all such illustrious people over here. I can't believe that I'm actually sitting with all of them. And the topic that we've been given is so relevant and so interesting for today, considering that 1st of July we see a lot of differences. Also, the SLP is pending, the writ petition rather is pending, where they have been asking for stay. I don't think that's going to come about, but nonetheless. I'll start with Siddharth. Yeah. My first question, actually not really the question, but I would want all of you to give just about 2 minutes about what do you feel with respect to the criminal law reforms which are coming about.
Yeah, good afternoon, everyone. It's a new legislation, of course. Everybody is anxious. Maybe some people are excited as well. There are a lot of changes that have been made. In fact, if you ask me today, to spell all these 3 new legislations, I mean, even in Hindi, even I don't remember. But of course, there are changes coming with the technological advancement. One of the speakers before us was talking about AI. But of course, I don't think so AI has anything to do with the new reforms. But of course, some part of IT is being brought in where there'll be examinations through video conferencing, and a lot of other definitions have been added, and some major changes have been made as well. Like one of the major changes is that when you come to rash and negligent driving, what has been added in the new penal code is that if the person driving leaves the site of accident without even reporting, that's become a major offense. So some changes have been brought in, going by the experience, what the government has thought proper to do. So let's see, but I think this is still too nascent to be commenting upon how it's going to shape up. Of course, jurisprudence is going to develop over the years. Let's see, I think it's a very new phase, and what Pallavi was saying about the petition pending in Supreme Court, I really doubt, because government has a very serious intention, and it will be applicable for tomorrow. So I think all in all, let's see. It's going to be a big change.
Thanks. Pramod sir?
Thanks, Pallavi. Basically, we were accustomed to adopt a particular jurisprudence since long.
That's right.
Now it's a demand of the day, and since we are developing everywhere in economy, technology, everything, so it was decided by the government that we should also match the international standard and development in the society, because the law can develop as per the society demands. There are 3 main stakeholders in this matter apart from the litigants. That's the one is that in the criminal law, that's the defense counsel, the prosecution side, including the investigating agency, and the judges. So there is a lot of apprehension in the mind of the defense counsel, because we are practicing as a defense counsel. We have adopted this habit for defending the accused persons. Some cases we are also acted as a prosecutor, as a special public prosecutor. So there is some happiness in one side, some stress on the other side. There's a defense side, and the judicial side we have already come across, like you have just mentioned, that's a PIL is pending in the Supreme Court. And Siddharth has mentioned that we are not hoping so much the government is serious. Apart from the seriousness of the government, we are coming across the comment from the sitting judges who are going to adjudicate this issue. This is the apprehension in the mind of the people. The judges should not make the comment on this issue, because the list is pending disposal before the court, and they are the person they are going to adjudicate. Nevertheless, they have made the changes, major changes. There's a procedural law in the Bharatiya Nagrik Suraksha Adhiniyam. So the purpose of this name is you have to protect the right of the citizen of this country, Bharatiya Nagrik Suraksha. And in that they have made a lot of changes so far the procedure, like the arrest, remand, bail, all these things, because in our criminal jurisprudence, what we have been taught from the college day, still we are learning the concept, the personal liberty. And the germane of the entire criminal law is the Article 21. So to meet that, they have brought all these
That's right, sir.
sections. And we as a lawyer, practicing in the defense side, we must be analytical. We should be ready to match the demand and do our preparation, because if you go through all the amendments, the debate everywhere, so my advice would be ki rather we should be the critical, we should be analytical, and we should go ahead, because tomorrow we are going to enter into the new arena of the criminal jurisprudence.
Thank you so much, sir. Salim, sir, what is your take on it?
Good morning, everyone. My specific say on the way new criminal laws have actually came up is very positive, because if I put up the perspective of a student from a classroom, a teacher's perspective from a classroom who is teaching criminal law to a generation of students in last 20, 30, 40 years or in last 150 plus years, what we see is this is a great welcome change which we have brought in our society, which was actually very earnestly required, because a lot of questions which were there in the mind of the student when we were teaching criminal laws in the classroom were very generic, very simple, very logical, which does not actually require a legal acumen to ask those questions. And questions are always complete. Answers are always lopsided or one-sided, or there is requirement of reformation in the answers. So all the four corners which are required to be there in any legislation, every legislation is made on four corners. One is the object clause, another is the subject clause, another the third is the jurisdiction of it, and the remedies. So when I assess the new criminal laws on these four corners of the legislative process or lawmaking system or lawmaking corners, I see that these criminal laws have actually provided answer to all those questions which we were unable to answer from the piece of legislation, which were somehow we have to be silent on it, or we have to provide an answer from somewhere outside the jurisdiction of India or outside our legal system. And introducing these changes in BSA or BNSS or the Evidence Act, this is something which is actually taking us not only improving the criminal justice system in terms of the time, in terms of the technology, in terms of the justice, in terms of addressing the justice system rather than only the punishment system. It has actually created a vibrancy in the criminal law justice system in terms of all the stakeholders, as Pramod sir, who is in the practice side, is saying that we are in a better position to provide answers to the defense, answers to the victims also. So this law is a great welcome and addressing a lot of things which are required at this point of time and way forward for us as a law abiding or criminal justice system society. But there are something which required some of the aspects which are required to be addressed more. But as of now, we can say that experimenting on this law for next 10 years will give us better insight and better justice system for our country. Thank you.
Neeha, you are so much involved in white-collar crime. What is your take on it with the changes that are coming along?
So thanks, Pallavi, and thanks for having us here, Ashima. But see, I look at it with a little bit of trepidation, and I'm not trying to be, sort of take a very different position from everybody, but I'm coming from a place of concern, which is twofold. One, while we needed, the question I ask myself is, did we need a reform? Absolutely yes, to the Criminal Procedure Code as well as to the Indian Penal Code, and of course the Evidence Act as well. Therefore, it is a welcome change. But how is it going to today impact the course of justice? That is yet to be seen, because we will see multiple challenges to multiple provisions. And Dubey sir will correct me if I'm wrong, that we will, and even me, Mr. Mir here, that the bail provisions and the remand provisions are something which have to be tested over multiple times today, and there will be multiple litigation over it. Even the right today, there is a bit of ambiguity on the procedural aspect of the right of an accused in a complaint case to, prior to cognizance, come and represent himself. So all these issues are going to go through vagaries of the judicial system. My worry is the concern in the ultimate dispensation of justice.
Correct.
How are we factoring that in? But of course, we cannot lose sight of the fact that with the advent of technology, with the advent of things like deepfake, with the advent of AI, we needed to upgrade our criminal laws to provide for offenses which will arise from things like this, which is AI and deepfake related. But at the same time, we have to be very careful and mindful as practicing lawyers of the burden on the system because of the delays that may or may not arise.
Yeah, I mean, I think basic fact of registering an FIR also, I don't know how equipped are our police officers to even, go...
With 156.3 as a power being diluted now.
So many things are there now. And I think Tanveer sir would be better equipped to inform us exactly what challenges are we looking at in terms of the law reforms that are coming along, sir.
Well, thank you very much. So, my take on, getting these three pieces of very important law, which has a direct interface with every person and citizen of our country, directly affects about 145 crores, is that the objectives which are stated in these three laws are not clearly defined. It seems to me that what the government is trying to do is to simply say to do away with colonial laws. And if what we call as colonial laws were so bad, then how is it that we have retained almost 90% of the old laws? Or the same laws which are applicable everywhere in the whole world, wherever Commonwealth is. The core concepts, core definitions are same. It seems to me that certainly with the the progress of technology, the new technologies must come to the fore for expeditious justice delivery system, and new amendments could have been welcomed. But what I see in the substantive law and substantive procedure is also a bit of enhancement or an intent to make our country a kind of a police state. I'll give one example of that. For example, in whenever there are custody deaths,
Right, sir.
unfortunately a woman is raped in custody, police otherwise, there is violence in communal riots, police accountability, executive accountability to the people of India. In 2005, the legislature amended 174 and brought in 174(1)(a), which covenanted that any time there are such heinous offences, besides an inquiry by a magistrate by an executive under 174, for example, in the case of a suicide, there will be mandatorily an inquiry by a judicial magistrate or by a metropolitan magistrate. So very simply, judicial magistrate first class in a state is equivalent to a metropolitan magistrate in a metropolitan area. Now, what the government has done is done away with the judicial magistrate and left it to the executive magistrate. So we don't understand, why have you taken the judicial magistrate out of the inquiry and left it to the executive? There is only one reason, that the government felt that the judges will always be a problem for us, but executive we can hold. Similarly, we had a judgment from the Supreme Court, Lalita Kumari, which said that any time a first information is brought before a police station, which discloses a cognizable offense, police should investigate a case. The 5 judges bench, where a lot of legal community labored, the judges toiled hard, wrote some very authentic, important judgments, have all been sought to be wiped out. Now before an FIR will be lodged, there is going to be a preliminary inquiry. What we irrefragably understand is 2 concepts in this initial statement is that, number one, when you give more uncanalized, unbridled power to the executive, power to the police, even the Supreme Court judges have 100 times said, even in Arnesh Kumar's case, that it is a seed for more corruption. So constantly, as the society progresses, whilst policing is important part of justice delivery system, there is also checks and balances. Secondly, even by bringing these 3 laws, the justice delivery system is not going to improve in our country, because the problem does not lie with defense lawyers or with the prosecutors or even with the cops. The problem lies with infrastructure. Infrastructure is what today in our country is less than 2 dozen judges for over 1 million people. The 40% sanctioned strength of high courts is vacant. I'll finish this with one example. The Allahabad High Court, Lucknow High Court, is hearing a criminal appeal in 2024, which was lodged in 1988. Why is that so? That is because if Allahabad High Court has a sanctioned strength of 170 judges, for last 2 decades you never had more than 80, maybe 110. So virtually the fact of the matter is that the governments consistently, whoever may be in power, they are not willing to invest in the infrastructure of justice delivery system. They are more interested in something else. Now, insofar as change of forensic laws is taken into consideration, that's more than welcome. That we can deliberate later in the debate. So I personally, as a lawyer, as a citizen of this country, feel that none of these 3 laws were absolutely needed at all. You could have retained the old laws. If you just want to change the name, we don't have a problem, if that's your problem. But what you could have done is you could have made suitable amendments, just as previous amendments were made, based on situation. Revamping the whole law, throwing the same law in the dustbin, and getting the same 90% law again with some amendments doesn't make any sense at all from anybody's perspective.
Thank you so much, sir. Pramod, sir, I have a question with respect to, how the law now changes from 1st, which is tomorrow. A lot of professionals are finding it difficult to keep themselves up to date. What is it that is, since you are a senior advocate and you've had so much experience with it, what is your word of advice to all the young lawyers also who are here as to how they should acclimatize to the changing environment?
I'll come to your question. First, Neeha has flagged one issue, that is the summoning of the accused at the complaint stage. The law as on date today, that is 30th June. If you are filing the complaint under 200, so your statement would be recorded. That is called the pre-summoning evidence. And the pre-summoning evidence is recorded. It's a deemed taking cognizance. Unless and until you have taken the cognizance, the magistrate had taken cognizance, your statement would not be recorded. After the recording the pre-summoning evidence, the judge has to examine the material, that is the pre-summoning evidence, documents and the complaint, and then decide to summon the accused or not. But in the new law, which Neeha has just flagged this issue, in new law, what they have brought, that at the time of the taking the cognizance, the court will hear the case of the accused, the prospective accused, and after hearing the accused, then court will decide whether the cognizance would be taken or not. So without taking the cognizance, how you can call the accused to put his defense at the nascent stage, at the stage where the court is itself not decided whether the prima facie case is made out or not. And if the accused is coming before you, disclosing his defense, there is adjudication on the dispute. And if you say, no, this is the case for the issuance of the process, so you are basically keeping aside his entire defense, the prospective accused. And this will also give the opportunity to challenge the order. There would be the multiplicity of the litigation.
Correct.
Mr. Mir has just mentioned that this is the infrastructure, the enforcement agency, that is the lack of the judicial officers in the different high court. Even in our Delhi High Court, their strength is, sanctioned strength is 60, we are somewhere around 40, 41. So you don't have the judges. Every day you are singing the song that is the pendency of the matter, pendency of the matter, pendency of the matters. But you are bringing the law which is going to be very complex. So I don't think how this act came into the picture. There must be deliberation on all these things. The intelligent mind must have done all these things. We are not going to criticize here, but now I'm coming to your question. There is a 248 Law Commission report that is in 2023.
Right.
Bharatiya Saksh Adhiniyam, and there was some dissent also. So, and then 268 Law Commission report, 277 Law Commission report. So these all were put before the amendment came into the picture. There is a dissent also in those reports.
Yes.
So being the professional, we should also analyze what were the dissent. And with the dissent, we can develop our case. See, I'm very optimistic. I won't say now the law is there, the president has given the assent, the law is going to be enforced midnight today itself. Today is the intervening night, that's the... So I'm not going to say they should have not brought, they should have kept the earlier law. I'm very optimistic. I have the firm belief, seeing the performance of the new law, the legislature would certainly bring the amendment in the law, seeing the performance, how the executive is doing these things, why the police agency, how the judiciary is doing. Because, see, I have very simple philosophy in my life. There is always blessing in the disguise. Mm-hmm. And once you have developed the habit of finding the blessings, you will find everywhere blessing, you won't find the disguise in your life.
So beautifully said.
So, being the defense counsel, practicing in the criminal side, we have to be very optimistic. And we have to be very analytical, which I have already mentioned. We always should be the high quality, the professionals. The lot of informations are there because we have gone through so many draconian law, stringent law throughout our career, like the POTA came, MOCOCA came, TADA came.
That's right.
Now the PMLA is there, SFIO, the Companies Act is 212 is there. These all are the stringent, or NDPS Act. Wildlife Protection Act, there is a twin condition, there are so many things. They are depriving the right of the citizen, UAPA. So we should not be so pessimistic, we should be optimistic. We are going to face the consequences, we are going to assist the court with the full strength, and our judicial system is very liberal. They decide the right of the accused. It is not like that we are entering the police society. Of course, there is a check and balance because the judges are also the part of the society. And they know what is the problem going on. They have the materials. They will have to educate everything. So the judges, lawyers, all should be the high quality.
So before you miss your flight, I might just want Siddharth to add, because you both are in the same flight and I don't want both of you to miss. Oh, okay. Oh, He's just, I thought he said that both of you are in. But let's just not make sure that Siddharth doesn't miss his flight. So therefore, Siddharth, since we have a lot of law students here and you're a young, bright lawyer, would you like to share some snippets or some pointers for them so that, they can benefit out of it pertaining to criminal law reforms or, anything
Yes, of
specific
course.
to that?
So you have the best panel here, starting from Mr. Mir, Mr. Dubey. Of course, the pessimism and the negativity, but I think I will remain in the middle. There's, of course, when these three laws are concerned, there's anxiety among the society. And maybe for Mr. Dubey, more stringent, more the money. So, I mean, of course. So, and though I tend to agree with what Mr. Mir said, that ultimately we may be reduced to a police state which we do not want. If 90% of the laws are similar, then why did we need a change? Coming back to what Pallavi asked me about the profession, I think all of you are in a journey which has just begun for you. And this is one of the brightest professions we have in our country today. And earlier also what our Justice Midha said, retired judge of the Delhi High Court, if you've heard him, he said that, look, here you get paid to talk, you get paid to argue, you get paid to interpret. So it's a beautiful profession, and the way things are going in the country, the way economy is going, of course, this is set to grow as well. We are maybe a generation down with Mr. Dubey and Mr. Mir here, Pallavi is there, and Neeha is here. I think over the years, the profession has completely changed. Not in terms of how the courts have started to function, but of course with the increasing number of disputes, the way Indian economy is going, of course we have the best experts on the panel today, white collar crimes. White collar crime is such a big deal today, and the new legislations which have come, whether it's the PMLA or what the SFIO is doing. So in criminal law also, it's much more to do than the Indian Penal Code. So I think sky is the limit. I wish you all the very best of luck, and I think you're going to be in a great profession. Thank you.
Thanks. Salim sir, my question to you is, now that all of these changes have been brought about, how is it that as professor and handling as a dean of a university, how is it that you are handling, how is it that you are coping up with it, educating the students with the new criminal law reforms that have come? How as an institution are you able to handle it, sir?
Thank you, ma'am. I would say that because the new criminal laws has actually created a new world for whether there is in terms of practice and experience, yes, there is a difference between a student who is passing out this year and someone who is practicing from 20, 30, 40 years or 10 years. But in terms of the new criminal laws from tomorrow onwards, the learning has to be restarted for everyone. So the post to start is for everyone. He's a 10, 20, 30 year practitioner or a judge who is listening the matter or who is going to adjudge the matter, or a teacher or a student. So for everyone, the post has restarted actually. And there is a great scope for the law students and the teachers and for everyone. Apart from this, there are a lot of aspects which are going to be challenging for the law students and law teachers and law institutions. And we have already been doing that since last 2 months. We have been instructed by the Bar Council of India. We have got a letter from the Ministry of Home Affairs that we have to start the training program. And we are not only training our teachers, we are not only training our own staff, but we have started training the judicial officers on that. After the training of our teachers, we have started training the advocates through the DLSA. We have started training of jail officers. We have started doing the programs in jails on the new criminal laws. So this is the last part that we are going to start the training of our students in the time to come. We have already adopted a lot of training frameworks which have been directed to us by the Ministry of Home Affairs, directly by the Ministry of Law and Justice. So Ministry of Law and Justice has directly involved in with the law institution, with the legal education institutions to adopt the new criminal laws, and start training programs for all the stakeholders. And we have been doing since last 2 months, so there's no problem in that. But what I see is the changes which have been brought are very understandable to the young minds of students and young lawyers, and in the modern time, because a lot of things are pro-technology, and a lot of things are something which are like e-courts, like one of the most important aspects which have been addressed by this by these laws is speedy justice in terms of timelines, which was lagging behind, not only because of the infrastructure of the court, but also because of the problems in laws and the implementation of laws. So one side of the criminal justice system in terms of delay in justice is addressed, and I hope with the infrastructure to come, and government is very proactive in terms of providing the better infrastructure aligning with the new criminal laws. So I hope the infrastructure will improve, and with that we will see that both the sides, the better laws and the better infrastructure of the judicial system, will be able to address the problems of the lagging behind and delays in justice system, especially in criminal laws.
That's
Thank you.
beautifully said. Neha, on that note, that since it's going to be day one for learning for all of us, how is it that we learn and unlearn and learn again? What's your take as a professional, and especially as a criminal lawyer? What's your take on it?
So, when I was just about starting the profession, I was told by one of my mentors that there is going to be no shortcut to reading. So now coming back to learning again, because certain things we just knew on the tips of our fingers and we took it for granted, like Lalita Kumari or Arnesh Kumar. Today we have to be mindful, that we are learning again. We shouldn't forget what we know because we need that still. And 3, we shouldn't get confused between what we knew and what we're learning now. So I think the best way of going about it is really and we have access today to so much, the students today have access so much more information and authentic portals that we didn't while we were in schools and colleges. So I think live law and bar and bench is something which should be a must for all, even for us as professionals to keep abreast. And opinion articles that are written, and of course, picking up a Bare Act and reading it for yourself. I think there's really no substitute to that. Investing the time in it if you want to go make a go of it.
That's really nice. Tanveer sir, you are one amazing criminal lawyer, and I really want that the students here actually get tips from you that you would like to share with them.
Well, the student community which will be who will be passing out in next couple of years, maybe 3 years from now, 4 years from now, and the moment you join the bar, you will have 2 kinds of cases that will hit your desk. One will be the cases which are pending as on date, which means at the strike of 12 o'clock today in the night. So cases which are already registered, cases where cause of action is already registered, which means that the offense has been committed prior to the law coming into the force. You will have to deal with those cases as according to the old law. And the cases which are registered, which means criminal felonies, which are committed and reported, which are actionable, cognizable offenses, non-cognizable offenses, which happen post the midnight today, you will have to work on new laws. So you will have to be abreast with both. The student community is best served in the university by having good, grasp on core concepts. In terms of the law professors teaching you basic constitutional rights, basic frameworks, basic concepts of, I went once to some university just to talk to the students, and I asked a gathering of about 800 students, what is evidence in a court of law? So, unfortunately, nobody was able to sort of, raise his hand. Well, very simple, a witness who is permitted by a court of law to step into the witness box, take an oath, and testify on a relevant oral account, and a documentary piece of evidence which is brought for inspection of a court in its original or secondary form. So, as Neeha correctly said, is that there is no alternative to reading and contemplating the core concepts. Then their interplay and interface with factual scenarios as to what kind of law will apply, what will be the proper procedure under which the facts will be molded into a particular petition and filed before a court of competent jurisdiction. And there you are, there you go, and there you start. So this exercise is for now for all of us, because we have to,
we are all
go back
students
and
now.
read. But in the larger perspective, what is important today for all of us, as I said, is that any stakeholder, whether he's a stakeholder in the first court, in the appellate court, in the revisional court, in the Supreme Court, as you are, will now be dealing with old cases for next about 30 years. New cases post this midnight.
True, sir.
So every judge will have one set of laws, one set of judgments, one set of bare acts on his right side, one set of bare acts on the left side, and his ability, his desire to have brilliant assistance on tips from lawyers, from police officers. So the job of the judges and the stakeholders in the justice delivery profession, including the law professors as well, will be doubly difficult. But we have to be optimistic, and we have to be up to the challenge. And therefore, game on. So let's go on and get to do what we do at our best. So let the student community ride the wave, have their core concepts, and when you hit the field, when one case that you do end to end, makes you a very strong lawyer. You grasp the concepts, you grasp the procedure, and then nothing is then difficult. The only problem which I see is, if you just take any, tomorrow all these students can accompany us and practically see what happens in the district court. Say you go to a court of session in Patiala House Court, only a walking distance from here. There is no sessions court in India or a magisterial court in India which on an average does not have at least 70 cases, 60 cases a day.
Correct. Yes, sir.
If you, out of 70 cases, have 25 cases where evidence is to be recorded, which means witnesses have been summoned, they are to testify, the lawyers have to cross-examine. Sometimes a witness will be cross-examined for half a day. As a concomitant result, the judge has to then mandatorily adjourn 19 matters. See, we don't do a jury trial in India where a jury is selected, then the jury is sequestered. The jury can't go back home, and the jury will be there till the trial comes to an end. So, core problem for justice delivery system in terms of expeditious is in lack of infrastructure. So, if a judge who is handling serious crime has 7 to 8 different murder trials in a day, how many witnesses will he examine? If a judge of the High Court has more than 100 cases, he's not a robot. You can't end AI to a judge. Ultimately, the judge is to decide on the basis of evidence. See, no human being can do about more than 40 cases a day, even as a judge. You're stretching it. The new laws will come with an explosion of petitions. And then a judge who had 120 will have about 180 cases now. But that's the reality, so let's face it.
Thank you so much, Tanveer sir. On that note, we'll just say thank you, because Siddharth's about to miss his flight, and he's probably going to hold BW Legal responsible for it.